All right, this is case number 21-67987. This is First National Bank of Omaha versus Judith Zell. That's as SGELC is the last name there. The matter is before the court set on for a subpoena hearing regarding a judgment that was entered on the 30th of June of 2021. The judgment amount is $6,204.11. This has to do with an effort to collect information in order to collect on the judgment. Your appearance for the plaintiff in this matter, please.
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of First National Bank of Omaha in this matter.
Thank you. Good morning to you, counsel. I'm now looking for Ms. Judith, last name SZELC. If you want to say something at this time. Again, I'm looking for Judith SZELC, living on an address on Central in Detroit, Michigan. Matter set on at 9:30. It's now 9:34. If you are on this Zoom in any way, please say something at this time. All right, counsel, it doesn't appear that the defendant is here. I'm going to wait just a few more minutes. I know that this is a purely an effort to gather information, and I know that at the time that this was, well, actually, the notice has this particular Zoom address. So we transitioned from a previous Zoom number, and so at times I've given people a bit more time to come into this Zoom because they would be rerouted from somewhere else. Given that defendant has not appeared regarding this matter, your pleasure at this time, sir.
Your Honor, because of COVID and everything that's gone along with it, my client has chosen not to proceed with any sort of supplemental proceedings. They do want to get this information, but if the defendants do not appear, they have no desire to move for show causes or bench warrants. So at this time, in light of the defendant's failure to appear, I'm going to remove my subpoena and withdraw it at this time. The court's blessing.
All right, and I will. We can wait another 5 minutes or so.
Sure, Your Honor.
I understand your position that if the defendant is not here within that time, then you'll withdraw the subpoena. So I'll take the motion to withdraw under advisement for the next 5 minutes or so. If the defendant comes in, we'll address this issue at that time.
Very well, Your Honor. Thank you.
Thank you, counsel. All right, this is case number 21-240518. This is Arnold Simpson versus Cam Marine. The matter is before the Court on Appeal from a determination by a magistrate, and that determination has been appealed to this court for a de novo hearing, meaning a hearing as if that hearing did not occur. Do I have Arnold Simpson on this Zoom at this time?
Yes, Your Honor, I'm here.
All right, good morning to you, Mr. Simpson. Do
morning.
I have Cam Marine on this Zoom at this time?
Yes, Your Honor. This is Carolyn Moulton.
Good morning to you, Ms. Marine. All right, just one moment. All right, and just before I come to you, Mr. Katz, I believe that you are on the are you the Anderson Raisin matter?
Yes.
Okay, I don't see the other side here yet, and I'll come to that as we have opportunity to do so when the other side is present. On that
Very well.
matter, sir. All right, so let me have Mr. Simpson and Ms. Marine, if you will raise your right hand to be sworn at this time, please. You do solemnly swear or affirm that the testimony you're about to give is the truth, so help you God.
Yes, Your
All right, thank you. And Mr. Simpson, this is your claim that you brought before the court, and therefore you get the opportunity to go forward first and to present to the court what you believe to be the evidence in this case, the basis upon which you believe you should be granted judgment in this matter. After you present your side of the case, Ms. Marine will have opportunity to do the same, that is to present her side of this and to tell me why judgment should not be entered. And the court will make a decision as to the outcome of this matter. All right, having said that, then, sir, I'm going to ask you again, you are Arnold Simpson. You live in Pontiac, is that correct, sir?
Yes, Your Honor.
All right, you filed an action with this court that was previously heard in the Small Claims Division, and you actually appealed this to be heard in front of a judge. Is that correct, sir?
Correct, Your Honor.
All right, and I'm looking through the file now, just looking at your complaint. Just one moment, sir.
Okay.
All right, and you brought a claim alleging money damages in the amount of $6,000. You indicated that you paid for boat storage in 2019 and 2020, along with charges for weatherization and paid to provision your boat for launch in 2021. You said you sold the vessel in 2021 after launching the boat. The owner realized that the water system on the boat was damaged throughout the entire system. This could only happen if the winterization was not properly done. Myself and the new owner have incurred numerous charges to correct the problem, reached out to Cam Marine, and have not been successful in correcting this issue. That's the nature of your complaint. Is that correct, sir?
Yes, it is, Your Honor.
All right. So go ahead and in as much as you're a sworn witness in this matter, you may proceed now to tell me what you wish to tell me regarding this matter, sir.
Okay, well, first of all, as I mentioned before, I've owned 3 vessels and had been boating for about 17 years. Always had my boats professionally winterized and stored. I don't know if you received, I sent over some information. I have a reference letter from my mechanic who was a marine mechanic for Gregory's, which was previous. He worked as a marine mechanic 27 years at Gregory's. He's the one that serviced my boat for 17 times or 16 times. He actually sent a letter of recommendation just saying what he had done and how he always winterized my vessel. I actually went to, in 2018, well, my first storage year was in 2019 with Cam Marine. And Cam Marine approached me because I was leaving.
Let me stop you for just a moment.
Mhm.
So Cam Marine, is that your name, ma'am, or is that the company you work for? Tell me, let's get this straight.
Camarine is the business name.
All right, and what's your name?
My name's Carolyn Moulton.
And you said Moulton, M-O-N-T-O-N?
It's Moulton.
Gotcha. Thank you, Ms. Moulton. Ms. Moulton, you're the person that they raised your hand and swore regarding this matter initially. Is that correct?
Yes, sir.
All right, and you work for and affiliated with Cam Marine, and you're responsible for things that take place there. Is that correct?
Correct. I'm the assistant manager. I do have the manager sitting beside me. His name is Ian Hilgendorf.
All right. And you said Ian Hogendorf?
Yes. Yes, sir.
All right. All right. And spell that last name for me, Mr. Hogendorf.
Hilgendorf.
All right. All right. Look like I'm getting Hilgendorf.
Yeah.
Well, I'm going to try to not butcher it too much. Hopefully, I'm on the right track.
No worries at all.
All right. You may have something to say about it yourself, Mr. Hilgendorf. Is that correct, sir? You may have something to say about this matter as well. Raise your right hand to be sworn, sir. You do something to swear affirm that the testimony you may offer in this matter is the truth, so help you God.
Yes, sir.
All right. Thank you. Thank you, sir. All right.
Thank
Then back to you, Mr. Simpson. Just wanted to clear some things up there. So you indicated that you had contact with Cam Marine sometime in 2019 for purposes of storing your watercraft. Is that correct, sir?
Correct. And I actually spoke with Tessa Ernest. I don't know why she was on the previous time we were at court. Tessa Ernest, I don't know where she is, but I spoke.
Tessa no longer works for us.
I'll come to you in just a moment. You may continue, sir. So you spoke with someone you indicate is Tessa Ernest. That's a male or female?
Female.
All right. And that's the first person you had contact with at Cam Marine. Is that correct, sir?
Yes, correct. And also previously at our previous case, she was the manager there at Cam Marine. So that's who I spoke with. All
right. Thank you, sir. And you may continue. Tell me what happened when you first spoke with Tessa.
Okay. All right. When I came to Cam Marine, I decided to store my boat there in 2019. I always got it professionally done, as I mentioned. I sent over a bunch of documents showing winterization procedures, and every marina that I've ever been to knows how to winterize a boat. I've never winterized one myself, but I do know basically the process and always have had it professionally serviced. When I went to Cam Marine first year, I had never had a problem in all the 16, 17 years I've been boating. I went to Cam Marine. Tessa mentioned to me, I was leaving town because me and my wife do an annual cruise. So I think it was sometime in October or whatever. She said, well, AJ, we can winterize your vessel. And I said, well, because normally I have a professional mechanic come and do it. And I've always had it done year in and year out. Never done it myself, but always had it professionally done. Matter of fact, the mechanic that did it actually, once again, worked at Gregory's Marine, which is now Cam Marine. He worked there for 27 years. Professionally did my boat every year, never had a problem. He ended up leaving, going to another career, but Cam Marine took over Gregory's, okay? Now, this should have been, I thought it would be kind of a cut and dried situation, but I didn't put my boat in the water.
Let me stop you for a moment.
Okay.
I don't need all of the kind of like commentary stuff. You thought it was kind of dry and all that. Tell me what happened, man.
Okay. All right. In 2000, I didn't put my boat vessel in the water.
Stop for a moment. I'm not an expert on boats. I've never owned one. I've never had one weatherized. I did work for the Marine there that used to be Gregory's, because I'm an East Sider, and I worked there when I was 16 or 17 or maybe 18 years old, unloading boats, and I almost froze to death. So by the grace of God, I survived. I can't believe that people do that kind of work in the dead of winter. I was a kid of probably 65 pounds, and I worked a while there, unloading stuff and so on and so forth. And like I said, I'm fortunate that I increased them. Other than that, I don't know anything about any of this. I know that there is such a thing as weatherization and so on and so forth. So you tell me, you have a plethora of experience that you've indicated to me for many, many years of voting. You have had the item winterized for many, many years, and you took it to what's now become CAM. You left it there 2 years in a row for purposes of weatherization. You went back, got the vehicle, you indicated, and then at some point you sold it. After selling the vehicle, you discovered some problems. Go ahead, as much of that as you want to break down and talk to me about. Go right ahead and do it, sir.
Okay, yeah. I was just going to ask a quick question. Steve, I sent over some information to the photo. Did you receive that regarding winterization?
Yeah. There is a packet of information that is contained in the court's file, and it's been submitted under evidence. What you have in that document is an item referred to as Lynn's service that shows that you had some work done with regard to this particular item. That work was done in July of 2021, totaling $2,809.82. There are other items within that pack, some of which would be in the nature of hearsay. I guess the critical issue that is being raised here is you're connecting this problem to CAM as opposed to stuff that occurred other than with CAM's involved. I also see another invoice item dated in December of 2019, indicating some $303 that was paid to CAM. And so a number of paper items that show a trail of dealings and relationships with CAM. And I don't think that is disputed here. I don't think that it is disputed that you left the boat at CAM Marine, that you left it there for certain services to be performed, and that you paid money for those services to be performed. There's a plethora of documents submitted to the court in that regard. So go ahead and tell me what you wish to tell me, sir.
Okay, yeah, so what I did, I left it, I didn't put the boat in the water in 2020 because of COVID. I assumed when I left the boat in 2019, they actually shrink wrapped, well, I left them, they were supposed to do the entire winterization, which included, basically when you do winterization, it's the engines and the water system, if the boat has a water system. And basically that's what all marinas do. Shrink wrapping was probably separate, but I left the boat in 2019, assuming.
Let me stop you. You said spring wrapping or something is probably another, say.
Shrink wrap. There's several procedures, yeah. First of all, we winterize the boat. All marinas, well, I've checked with quite a few just to get the winterization procedures to winterize a boat. Okay, I talked with a lot of local marinas in the area, visited them, went online, researched, because I knew, but I wanted to make sure that I was under the impression that I wasn't being misled after 16, 17 years of seasonal boating and winterization. So I checked with a lot of marinas and found out their winterization schedules. And winterization is basically, if the boat has a water engines, you winterize the engines. They have to fog the engines, do some other things, get water out of the engines. And also if the boat has a water system, they will winterize the water system, because you know water does damage the boat, especially if you have a head, a toilet, any showers, sinks, like in any vessel. But so I left the boat, and then they Tessa had agreed, well, we'll take care of all your winterization and we'll also shrink wrap it. Now, you don't, the last part of winterization, from what I understand and what I've researched, is that you don't shrink wrap the boat first and then winterize the engines and stuff later. You do the engines and water system, and then you shrink wrap. That's a separate price, shrink wrapping. So you can kind of separate those two, but you can't separate doing the engines and the water system on a vessel when someone drops it off and says, hey, they ask you to winterize their vessel. 2020, once again, I did not put it in the water. So I assumed after all that year that the boat, I never put it back in the water due to COVID. So it sat there shrink wrapped for 2 years, basically. And I decided to sell it in 2021, assuming that the boat had been fully winterized because Cam had promised to do that. Now, until I wasn't, so when I sold the boat, I was still at their facility at Cam Marine, met with the buyer, the owner, my new owner, and they pressured me to get the boat out of there, and where was he going to put it? Meanwhile, their water system was not working, so we couldn't plug up the water to even check the system. So we had to actually take the boat to what is called Kings Marina, where he decided to store the boat. Before he purchased the vessel, I asked Cam Marine, and I paid them $813 or whatever to commission the vessel. Commission the vessel means to check all the systems, make sure it's right, put it in the water and whatever. They charged me to commission the boat, replace the water pump, which, why would you replace a water pump and the whole system's bad? Charge me for a water pump that doesn't work, it's not gonna work because the whole system was frozen. I didn't realize that until they asked me to leave Kings, get the boat out of there, which we did, because they never turned on the water. They wouldn't turn on the water so we could test everything. Took it over to, we did a sea trip so I could show the new owners how to operate the boat. Took it over to Kings Marina, which is a local marina right there near Cam. And we plugged up the vessel, and I went over, started going over all the systems with him. He asked me how to work the water system. So I put the hose on the system, decided to put water into the boat to show him how to work it. I noticed that the water pressure was really low, it was barely coming out of the faucets, and I didn't know why. So I opened up the hatch, looked in the bottom under the hatch, water was going everywhere. I knew immediately, just from experience, that this system's been frozen. This system, they never winterized the water system. They did the engine, didn't winterize the water system. I had a problem with my generator, which they couldn't fix, which is here nor there, but caused a lot of damage to this vessel. I got an estimate, and that $2,800 estimate is an estimate for the repairs. I reached out to Cam on numerous occasions, talked with Tessa, said, hey, you guys need to look at this. This is wrong. I mean, I paid you to commission my vessel. You charged me to put it in the water. You told me this is what's up. We put a new water pump on it, but you never even mentioned, I know why, that the water system didn't even work. Why replace a pump? Charge me to commission the vessel, put it in the water, and then you know the system doesn't work. They're the professionals, not me. They do this all the time, and they're supposed to have marine mechanics. So I followed up with, and I did send a letter of recommendation from, notarized from my marine mechanic, once again, who has 27 years of experience in boating. And he verified that, hey, AJ is always, they call me AJ, has always winterized his vessels. I've done it, all of them, always professionally done. I've never said I would do part of it. When I left it with Cam, I left it with the understanding that they're professionals. First time I ever got anyone else to do it. I've always had it professionally done, but first time they asked me to do it, I let them do it, left the boat in their hands, got it after 2 years later, and found out that they didn't do the water system. But it sat there for 2 years. I paid them for storage, for the winter storage in 2019. I paid them to keep it on land in 2020. And I paid them for winter storage again in 2020 at the end of the season, because I never put the boat back in the water. I just got it out in 2021 to find out that they did not do what they were supposed to do. They left my generator wide open. They moved the boat. The shrink wrap had been ripped off the door on the back of it. The system was just messed. It was just ridiculous what happened. And so I expect to be paid, or compensated, because I sold a boat that was damaged very badly, and there's no way in the world that I would take it upon myself after 16 years just to decide, well, I'm just going to let the boat go to heck. I wouldn't have done that. That's not the way I operate. I mean, and my personal character, and like I said, hurt because I thought the Cam Marine was a professional business and they would take care of it, which they didn't.
All right, let me ask you a couple questions that I'm going to Cam and I'll get some inquiry on there from what they have to say about this matter. And Mr. Ferguson, I'll be with you shortly. Mr. Katz will be back to you. Mr. Kim, I will indicate regarding the suffix 7987, it does not look like the defendant in that matter is appearing. And so I will note that you are withdrawing the subpoena on this matter. And,
Thank you.
No, thank you, sir. Okay. All right, and that was in reference to 7987, back on the record regarding 0518. So in terms of the billing for services rendered, I know that you indicated that you spoke with one of the persons at Tester. You spoke with that person and who told you that they would take care of the winterization of the boat. You paid a certain fee for storage in 2019 and 2020, correct, sir?
Correct.
Right. What did you pay by way of storage fees during those times? What did you understand the storage fee to be? How much per month?
Storage fees are just to keep the boat on land, basically. It's not considered winterization. It's actually, well, you're going to keep your boat here. It's going to charge you to put it up on storage.
Didn't ask you that question. My question is much more specific than that. What was the storage fee that you paid? How much? How much money are you talking about with storage fees?
$1,430, I believe, per season for winter storage. That's twice, and also paid for summer to keep it stored on land. I think it was $900 or whatever.
Gotcha. Now, now you anticipated my next question. My next question was, what amount did you pay for weatherization, or was that to be included in the storage? Talk to me.
That was not included in the storage. The amount of winterization, I think it was a total. They said when they I got a bill for $700, I think, to shrink wrap it. Another $300 for winterization. Okay, and that's, I guess, I assumed. First of all, when they said they would do the engine.
Let me stop you. Let me stop you on your assumption. Your understanding as it relates to the $700 and the $300, a total of $1,000, is that would cover the winterization for the 2 winter periods, as well as the wrapping of the boat over that period of time, correct?
Correct.
All right. So $1,000 over and above the storage charges was the amount that you understood that you paid that would result in the winterization and the wrapping of the boat. Is that correct, sir?
Correct. Mm-hmm.
Now, when you paid for winterization at other locations, as you indicated, over a 17-year period of time, were those amounts in keeping with what you would typically pay for winterization, sir?
From what I understand, well, yes, I would say I was under the assumption once a person told me they winterize my vessel, I paid what they asked. I didn't bother to really go into detail, and really I didn't pay, as long as it wasn't something enormous like a $4,000. I mean, no one pays any attention. I just said, winterize my vessel, let me know what you're charging me. I'm going to pay you. And that was, I never once. Okay.
Yeah, here's what I'm getting at. You paid $1,000 for winterization and care for your boat over a period of 2 years, over and above storage. And my question to you, does that sound roughly about what you would have paid, give or take a certain amount of money for winterization at other times? Just based on your experience, what did you pay to have your boat winterized in other years?
It was in the ballpark. I would assume. I mean, I hate to say assume, because every year, once again, out of all the years, I just paid what the person would ask me for.
What did they ask you? That's what I'm getting at. What did they ask you for in those other years? $500 a year, $1,000?
Well, I would say, I would say probably 600 for the winterization of the 600 or 700, just within a ballpark. Give or take $200 or $300. Okay.
Gotcha. That's what I was getting at. All right, sir. All right. And so they were to the next question I have to use that that Cam was to make the boat, for lack of a better way of putting it in my own language, seaworthy, right? And you paid some money for the boat to be made seaworthy because they had to replace a pump or something, and you spent some money on that. Is that correct?
Correct.
All right. And that amount, you mentioned it to me, but the amount that you spent for those services were how much? Was how much, sir?
$813.
So at some point, under some pressure, as you've indicated, that you have the boat moved to another boating entity. You then sell the boat, and in the process of transferring that boat is when you discover that there are problems with the water supply as it relates to toilets and things along that line. Correct, sir?
Correct.
You said there was a problem with the generator as well, but that you're addressing the issue as it relates to the water and how whether or not the boat could in fact be put on the waters as it relates to the use of toilets and the use of water supplies. Correct?
Correct. The generator was a separate incident, though.
Thank you. How much did you ever get the condition straight as it relates to the use of the water supplies and the water lines in the boat? Did you ever get that straight? You have to get that taken care of.
You're kind of breaking up. Can you repeat that, please?
Yeah, did you ever get those conditions corrected as it relates to the toilets, the water? You said that there was water running in, you had low water pressure, and et cetera. Did you get that situation taken care of?
No, I have not yet. The owner is still waiting for some resolution because I sold him the boat. That should have been repaired. No, I have not. I did get an estimate. The estimate is just an estimate from a local marina for $2,800, and that can change if they find more damage.
I know you've only said that 3 times. It sounds like 6 because I have big ears and I hear it right the first time. So,
okay. I'm sorry.
So you haven't had it repaired, but you do have an estimate, and you're not sure whether that estimate is going to cover it or not. It could be more, it could be less. It's just an estimate in the nature of about $2,809.82. Correct, sir?
Correct.
Anything else you want to tell me at this time, Mr. Simpson?
Last but not least, I may have kind of repeated myself, but I did do my due diligence to once again, did a lot of research online. I went to several marinas, got their local pricing to see what they considered winterization. And I think that you will find that if any marina that you talk to will say what winterization is, and basically if you have water systems and motors, but they all told me the same thing. If you have a water system, we'll do water system, and also last but not least, when I've talked to marinas, and I'll also mention that all of them actually, when they do, you leave your boat in a person's hand that's supposed to be professional, and that's all I did. I never did my own boat, and always left it to be professionally done. I would have not gone out of my way to say I'm not just do part of it myself and let them do it. I don't know why they decided to shrink wrap it without finishing the engines or the water system and cause that damage. But basically, that's it.
All right, and so just so I make sure that I understand those last things, your position is that they did not winterize the interiors of the boat, the water operations, and that it was unreasonable for them to wrap it and allow it to sit in the winter without having done that. Correct, sir? That's what you're telling me.
Exactly.
All right, thank you, sir. Thank you, sir. All right. Let me hear from Cam Marie. Just sit tight for just a moment. I'm going to take a look at a couple other cases. I'm coming right back to you, and I'll hear the additional testimony in just a moment. All right. Thank you. All right. The court calls at this time case number 21-142-608. This is Raisin Anderson versus Esurance Property Casualty and Casualty Insurance Company. The matter is before the court on the return for a final pretrial conference, an adjourned final pretrial conference, where there was an issue of discovery that was requested, and the court did allow a certain discovery to occur. The court did sign a protective order on October 1st, 2021, and your appearance for the plaintiff in this matter, please.
Morning, Your Honor. Zach Cass on behalf of the plaintiff.
All right, thank you, Mr. Katz. And you just put your P number on the record, if you will, sir.
78426.
All right, thank you, Mr. Katz. And for the defendant in this matter, your appearance, Madam Counsel.
Good morning, Your Honor. Christina Corcus, appearing on behalf of the Esurance, P number 82553.
All right, thank you, Ms. Corcus. Good morning to you as well, ma'am. So I take it that that something went awry somewhere. I know that there was an expert that was hired in relationship to salvaging or getting some information from some electronic device or devices that the court allowed by way of its order of discovery. So go ahead and who wants to go first?
Your Honor, I'll go. I think I have a few motions up for today. And since the court already mentioned the expert motion, I can start with that for sure. We do have a motion for sanctions in this matter. The court is absolutely correct. The court had ordered that plaintiff produce her cell phone for the extraction of her data, which has not been produced yet. And we have a pending motion, second motion to dismiss on that basis. Counsel, without my permission and without me knowing, contacted my expert and spoke to her directly. Your Honor, that's clearly in direct conflict and against the court rules. And for that reason and for this conduct, I am asking the court for sanctions.
Counsel?
Judge, the only thing I discussed with this person who is an expert was the method by which she can collect the data. It was the day before the collection was due. I contacted her and I contacted Ms. Corcus and asked her who's going to be collecting this data. She gave me the name of somebody. I called that person and I said, the only thing I discussed was the method by which she can collect the data. I didn't discuss anything about the case. I didn't discuss the content of what the data was. I didn't discuss the defense counsel's name. I didn't discuss anything wrong. The court rules are really clear, Judge. They specifically protect documents and tangible things. Basically, the conduct of
Mr. Katz, one second. I got a lot of feedback coming from something. Do you have something going on? Who? All right, let me make sure everybody's on mute except you at this time. Just make sure your devices are mute because I'm getting some feedback that I'm trying to find out where it's coming from. Okay, Mr. Katz, you may continue at this time. You indicated to me, of course, that you had you contacted the person that was the expert to ask about the procedure or process that they would use in regard to gathering the information. Is that correct?
The only thing, I didn't discuss anything about the content of the case, the content of the data. The only thing I discussed with this person was, how do I get this data to you? What is the method by which I get this data to you so you can do your job? And the court rules are clear. They specifically protect against conducting expert discovery outside of, interrogatories and depositions and the methods that are prescribed in the court rules, but they have no blanket prohibition on me dialing somebody's phone number to figure out how I get some data over to this person. I didn't ask for any documents from her. I didn't ask for any tangible things from her, which is what the court rule protects. I didn't ask her for her mental impressions. I didn't ask her for her conclusions. I didn't ask for any opinions. I didn't ask for any legal theories. I didn't ask for any facts about this case from her. I didn't attempt to solicit any information from her. There's nothing wrong that I did. Nothing that I did is sanctionable. And this is purely, I'm sorry, Judge.
Yeah, I'm listening to you. That you're hearing that feedback now, but go ahead, sir. I hear.
That was it. I mean, there's nothing sanctionable that I did.
Your Honor, if I briefly respond.
Yeah.
Within my motion, MCR 2.302 in paren B, paren 4, and paren F is clear that certain documents and conversations with an expert are not discoverable. Doesn't matter what the communication is. If a party has retained an expert, Your Honor, you do not contact them. I don't care what the conversation was about. That could have gone through me. He contacted my retained expert without my permission. After the court had ordered, the method in which her data would be collected was her producing her physical cell phone. And the court gave me 14 days to do that once I was in possession of it. So I'm not sure why we were still trying to determine the methodology when the court's order was quite clear on not one occasion, but two. So, Your Honor, I think sanctions are warranted in this case for contacting defendant's retained expert.
Judge, you cannot order a sanction unless the court rule provides for it. And the court rule that Ms. Corkus just referenced to you has nothing to do with. Ms. Corkus, could you please mute yourself because there's the feedback from your microphone.
Thank you, Ms. Corkus.
The court rule that she just referenced has nothing to do with what we're here for. All it does is extend the work product doctrine to communications between an attorney and the attorney's expert. There's no prohibition on me contacting an expert for something not related to this case. And when I talked to this expert, I made no reference to our case. She didn't even know what case we were talking about.
All right, I've heard enough on this motion. Listen, the court rules always aim, obviously, at preventing acts of bad faith and untoward behavior. As I look at this, is it the wisest thing to do to contact someone else's expert, even to ask them for a referral, their phone number, or to ask them the procedure or whatever that they're going to use in the advancement of their practice? It's probably not the wisest thing to do. It's because the rules are drawn up in such a way that they don't really address the issue of good faith, bad faith. But the reality of it is that the rules, the purpose of the rules is to prevent bad actors, to prevent bad faith, bad behavior. And there's nothing indicated here that is of that nature whatsoever. Therefore, on this particular motion, the motion will be denied as it relates to the petition for sanctions in this regard. All right. Ms. Corkus, I believe that you have a couple other motions up at this time. Go ahead on what you favor at this moment, Madam Counsel. And I'm sorry, we had you mute yourself, so you're still on mute. So if you
all right, yes, I apologize. Thank you, Your Honor. I do want to start with my second motion to dismiss for spoliation, and I will note that I don't believe counsel responded to this, so on that basis alone, it should be granted. But as this court is aware, on September 15th, we appeared before the Honorable Court, and you granted my motion to compel plaintiff's social media data, as well as her password, username information for her Facebook, Instagram, and iCloud. The day the morning after the court ordered it, I had some inclination that Ms. Anderson would not preserve evidence against spoliation. So I shotted her Instagram page, and she had, I believe, 321 posts, Your Honor. About a week or so later, over 60 posts were deleted from her Instagram, which is clearly a destruction of evidence that she knew she should have preserved because of the court's order. And I find it quite interesting that over 60 posts were deleted the day after this honorable court entered an order granting my motion to compel that data. Your Honor, this is the pure definition of spoliation. She has deleted and destroyed evidence that I could have used for my defense of this matter, and Esurance no longer has access to that because Ms. Anderson deleted it. And I'd like to point out that this court has another motion to dismiss for spoliation held under advisement, that she destroyed her phone after there was a pending motion to compel her cell phone for the data that we wanted to extract. Your Honor, Ms. Anderson has made it a habit to destroy evidence and to destroy information. As this court is aware, it is our position that this was a stage loss based on the opinions of our accident reconstructionist, Randy Ricotta. And Ms. Anderson and all her fellow alleged passengers have made it quite difficult for Esurance to be able to obtain information because they've all continuously destroyed information and or failed to provide information for investigation of these claims, which have resulted in dismissals of the other claimants' cases. And for the reasons set forth in my motion and as represented today, I am asking the court to dismiss her case for clear spoliation of evidence.
Well, Judge, I would just say that she's kind of misrepresenting what's going on here. Those other individuals, Ms. Corcus, could you please mute yourself? She's misrepresenting what's really happening here. Those other folks are not plaintiffs. Those are people who are not involved in this case. They had their own lawsuits, which we were not allowed to litigate because we weren't parties. She wants to make them parties to this case and impose res judicata because their cases were dismissed. Therefore, my client's case should be dismissed. That's not proper, and there's no support for that. With regards to the data she's alleging my client destroyed, I'm not an expert in analyzing electronic data. I don't imagine you're an expert, and I don't know that Mrs. Corcus is an expert, but I don't see any expert reports saying that she deleted these particular posts on this particular day. There's no indication as to when whether posts were deleted, when they were deleted, for what reason. There's no testimony on that. There's no nothing. I'm not an expert, Judge. You're not an expert. Ms. Corcus is an expert. I think this is something that we would need an expert to discuss before you issue an opinion dismissing this case or imposing a jury instruction regarding spoliation.
Your Honor, if I may respond briefly.
Just one moment, counsel. Let me ask you, Mr. Katz, why didn't you put a written response to this motion? I know that this has come up before, and I understand that. Madam Counsel did raise the issue that you didn't give a written response on that motion. I do know that motion is filed with this court on October the 17th.
Judge, this isn't a motion for summary disposition. There's no requirement that a response be filed. I can make an oral response at the hearing if I please. This is not the type of motion that is admitted if not responded to. There's no court rule that requires that.
Yeah, I understood that. I guess your better argument is that the motion was just recently filed and that therefore you didn't get around to giving a written response to it because the court always favors a written response. All right, thank you.
I did have a number of responses I did have to write, for today's date. So.
All right, thank you, sir. Ms. Corcus. Yeah, on the listen, what you've shown me in this document, it would tend to show that there may very well be some spoliation, but that is more would seem to me in the purview of give us some expert testimony in that regard. And then the final thing that I'll mention as it relates to whether or not this can be bootstrapped into what happened with some other person, that's not really particularly relevant in this case, that there might be some other bad actors. It does appear to me from the issue that has come up here that there may very well be some failure to be more than forthcoming as it relates to the electronic data that the court is ordering over. But I don't know that there is enough here to establish that, number one, that has in fact occurred. And then secondly, whether or not the proper remedy, if that is in fact the case, whether the proper remedy here is dismissal of this matter. Go ahead, Ms. Swartz.
Your Honor, I just wanted to respond to counsel's argument. Respectfully, I don't know why an expert is needed. The photos attached to my motion are clear. September 16th at 6:39 a.m. That was the day after the court entered an order compelling this information. She had 321 posts. September 28th, 7:19 p.m. She had deleted over 60 posts because her Instagram had went from 321 to 261. When you look at her Instagram, the alleged accident occurred on May 9th of 2019. Her post started on April 29th, 2019. And then the next one is not till January 13th of 2020. So the 60 posts that she deleted, Your Honor, was immediately before the accident, on the date of the accident, and a year afterwards. That is clear destruction of evidence, Your Honor. This case is prime for a dismissal. And if anything, a jury instruction should be held if the court is not going to dismiss this case, that she did destroy relevant evidence that this honorable court found a day before my client was entitled to. we can no longer access that because she deleted it. She destroyed it. 60 posts, Your Honor, 60. It wasn't just one or two. She deleted 60 posts, a year's worth, immediately before and after the accident. Well, this alleged accident that occurred.
Well, Judge, I think you already indicated how you're going to rule on this one. That's the exact same argument she gave before.
Ms. Corcus, I need you to mute again. For some reason, when he starts talking, you kind of get some feedback, but go ahead.
Your Honor, that's the exact same argument she made at the beginning of this hearing, that you already issued your opinion. This is not, I mean, she's injecting herself as an expert witness in this case. I'm not an expert in analyzing Instagram posts and whether, you know, how they, I don't know, Judge. I don't know how this works.
Well, I don't think that she's projecting herself as an expert for sure. What she's pointing out is something that arguably seems somewhat peculiar, and that is that before there is a requirement for release of certain information, it seems that certain posts that are in storage are deleted, and then right after the court issues an order, and before it's time to gather information, it seems like a number of posts are deleted. Again, the issue becomes whether or not an expert can actually verify those kinds of things and tell us what that actually means. Because at the end of the day, that's kind of the way that this stuff is done now. Experts have their opinions about what is being done and what is not being done, and that kind of result. I do think that at a minimum in this case, a jury instruction would certainly be warranted, and just perhaps a jury instruction be warranted, but certainly cross-examination and inquiry regarding items being deleted and what the intent of that might have been, leaving those questions open for a trial of fact. And that's a minimum that would happen here. I mean, that's not anything new. That's what happens in all cases along the discovery path, and sometimes before that. It turns out that people act a certain way, behave a certain way, and what those acts and behaviors mean are issues that can be brought before a trial of fact to determine which direction that should go. So that's kind of a minimum in this case. What I'm going to do is I'll take the motion to dismiss under advisement. You would need a comprehensive statement from someone who is an expert to say that there has been spoliation of evidence in this case. And I'll grant you a period of 30 days to get that. And if that can be established by an expert on competent science or evidence, then I think that you may very well be entitled to something more far-reaching than an instruction. I'll review that at that time. All right, so what else is going on in this case?
Judge, she mentioned the cell phone that my client was ordered to produce. I have a motion for reconsideration.
Yeah, respectfully, it's my motion. Can I argue it?
All right,
Sure.
I just have one more motion, Your Honor, and I'd like to present my arguments before council.
Come on, let's go.
Your Honor, I have an additional second motion to dismiss for violation of court order. We were before the court on September 15th, and for the second time, the court ordered Ms. Anderson present her cell phone for extraction of data that has yet to occur. I still don't have her cell phone, and on the record, counsel did make reference that she lived out of state. That's why the court gave me a 14-day window from receipt of the phone to extract any data I need, harvest it, and send it back. We still don't have the cell phone. Counsel continuously has represented that he filed this alleged motion for reconsideration, which I don't have in my possession. I don't show that any motion has been filed despite my multiple requests for same. In addition, although plaintiff produced her iCloud password and username, when I log in, Your Honor, it asks for an access code, and I asked counsel for that access code. The one that they gave was incorrect, and I asked for it, another one again, and that went unanswered, and they ignored it. So I was not able to access Ms. Anderson's iCloud information to review the data as the court had ordered. For these reasons, and for her continued violation of court orders, I am asking the court to dismiss the case.
Judge, we filed a motion for reconsideration regarding the cell phone data. I want to, there was a dialogue between Ms. Corcus and my staff about collecting this Instagram, Facebook, and iCloud data. That conversation went on until Ms. Corcus stopped communicating. There was never a time when my staff started ignoring Ms. Corcus. So if she wants something, she can come get it. But there was never a time when we started ignoring her requests. And we gave her a significant amount of data. She's pretending we gave her nothing. We gave her all the passwords. We gave her all the access to everything that we had from Facebook, everything we received from Facebook, we sent over to her. So I don't know what she's talking about when she says that we're ignoring her requests. Secondly, I did file a motion for reconsideration. If she didn't receive it, you know, I made reference to it in an email to her. I thought my staff sent it over, but Ms. Corcus never specifically asked me for the copy of the motion. So when she says that I never served it on her, I don't know what she's talking about. But Judge, this is an issue of a cell phone. My client works as a DoorDash delivery driver. She has children. She cannot be without her cell phone for 14 days. The issue here is that Ms. Corcus wants her expert to examine the phone, extract data, but the same amount of data can be extracted remotely without the cell phone leaving my client's hands. So there's no reason to give up this cell phone when the data can be extracted remotely. This person's livelihood will be, you know, put on hold for 2 weeks just because Ms. Corcus wants this cell phone in person.
Your Honor,
Just a moment. I don't see the motion for reconsideration on this matter. Ms. Corcus, did you get the motion?
no, Your Honor, and counsel was incorrect and made a misrepresentation because I can refer this court to an email where I specifically asked him for same after he alleged one was filed.
All right, so here's what counsel's saying, and I think it's very clear. He's saying that, listen, there's a way to get this information without the defendant, the plaintiff turning over the phone that get extracted remotely.
That's not true, Your Honor. No. My expert has not confirmed that.
Have you made that inquiry of your expert?
No, Your Honor, I have not. Oh, I did discuss it with her and she said that that's something she would look into, but she's not sure she can do that.
All right. Well, obviously, the least intrusive way of doing it is the best way to do it, particularly where people are having financial kind of issues in this COVID environment, and the cell phone is key to our employment. So, counsel, Mr. Katz, what is it that what other actions can you take that might enable this information to be transmitted? Ms. Corcus seems to be working on it in the sense that she's asked her expert to determine if that can be done remotely. What is your client willing to do? Is she willing to meet somewhere? If
She can take it to somebody in her area, then that's fine. If they can send her or they can communicate with her to get this data. I don't know the exact ways to do it, but I've talked to, I spoke to an expert who does this in Tennessee, where my client lives, and they said that they can do it remotely. Ms. Corcus's expert has not indicated that she can't do it. In fact, she indicated to me that it's possible.
Well, yeah, I think we need to give that process an opportunity to for that to occur. All right, so that's got to happen. You got to try to do it remotely. But I'm concerned now about the other issue.
I'm sorry, can I just point one thing out? I do want to correct myself. I did see in an email, Ms. Corcus requested that I forward her a copy of the motion for reconsideration. I thought my staff did that. Clearly, Ms. Corcus still has not received it, but I do want to make that apology.
And I don't have it in the court's file. I do have all of Ms. Corcus motions in front of me. I don't have your motion. Maybe they were hand delivered by Ms. Corcus' office or whatever, but I have all three of her motions, and I don't have the motion for reconsideration. But if the reconsideration is on the issue of whether or not the document, the evidence can be extracted remotely or without the phone being turned over and absent for a couple of weeks, that's a more reasonable way of doing it. That makes sense. Even on an oral motion, it would make sense for that to be raised. And so the court would grant the petition to the extent that that can be done. If it cannot be done, then the quest for evidence in this case looms large, given that there are some claims of spoliation. And so she's got to make that phone available. And that process of doing it remotely has got to be explored and drilled down on. Otherwise, she's going to have to turn the phone over. So let's get that done within that window. Within that window of 30 days that I've given on the other issue. Ms. Corcus, there was something else, and I know I'm moving on to some other case, so my mind slipped for a moment. There was something else that you raised in this last motion that I feel like I'm missing something. Go ahead.
Yes, Your Honor, it was with regards to the iCloud information, the password and the username. And counsel made another misrepresentation. The emails are attached to my motion, and his staff did stop answering me. I responded to his staff and said, the last passcode you gave me is incorrect. Please give me the correct passcode that I just sent over. And that correspondence went unanswered. So I was unable to access any of the iCloud information because they failed to provide that. So that was the second basis for my request of a dismissal for her failure to comply with the court's order and provide that information.
Yeah, that part seems to be, seems to be inexcusable. Well, something's going to happen, I think, in the next 30 days, one way or the other. This is going to work itself out. It's going to end up being something that's dismissed, or the parties will have what they need, or be ready to argue at the next level for trial and things along those lines. So those passwords have got to be turned over until they're correct. I don't know what's going on with that, but whatever it takes for Ms. Corcus to actually get access to the information. I understand that passwords and what have you been turned over, but there is some code or something that is needed. And so there's not really a surrender of the information until she actually has access to that information. And if the passwords are not enough, then whatever else is needed has got to be provided in this matter. Otherwise, that means that evidence is being secreted, and that the case should not be allowed to go forward where the plaintiff does not wish to allow discovery under a court's order. So within that 30-day window, that additional information has to be turned over to allow actual access to the evidence that Ms. Corcus seeks. And in this case, I think it's very clear that she wants, and the court has ordered that she be permitted to see the iCloud information and other electronic information, and she would need the proper access codes in order to see that. And that's got to be tendered and done accurately over the next 30 days, together with the other items that the court has rendered in its determination on these motions. That is my ruling in that regard. Trying to keep this to some picture of what might happen during this year. And so I'm going to bring you back. I'm going to bring you back on the 7th of December. December 7th at 9:30.
Thank you, Judge.
Your Honor, can I ask for one more request if the court will allow?
At this time.
In order to, I know the court had wanted me to retain an expert for my second motion to dismiss for spoliation. Will the court allow my expert to access plaintiff's Instagram to be able to conduct that review to give the court the opinion the court wishes?
Absolutely.
Okay, thank you.
All right, you'll put that in your order. The first motion, the court denied the first motion. The other orders are the court's determination on issues of evidence, and somebody set that forth in a written order for me and submitted out. I'll sign this thing.
And Your Honor, the second motion to dismiss for violation of court order, was that one also held under advisement?
That's correct.
Okay. I will file orders. Thank you very much, Your Honor.
Thank you, Judge.
Thank you, Counsel. Good day to the two of you.
You too.
All right, this is case number 21-65615. This is Affiliated Diagnostics of Oakland versus City of Detroit. The matters before the court on an adjourned date for motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Michael Fergustrom for the plaintiff, bar number 48864.
Thank you, Mr. Ferguson, and good morning to you. For the city, defendant City of Detroit, your appearance.
Good morning, Your Honor. Patrick Cunningham on behalf of the City of Detroit.
All right, thank you, Mr. Cunningham, and good morning to you. Your P number, if you will, Mr. Cunningham, for the record, sir.
Sorry, Judge. It's P67643.
All right, thank you, sir. All right, and this is your motion regarding this matter. Go right ahead, sir.
Your Honor, before we begin, may I interject?
Yes, sir. Yes, sir.
I was somewhat surprised. I had this originally calendared as a pretrial. I noticed over the weekend that there was a notice to appear for a motion for summary disposition in this case. My file does not contain a motion for summary disposition. I checked with the firm to see if anybody had one and it had somehow not made it into the file. I simply do not have a motion for summary disposition in this case. I don't know if it was a service issue or if something else went wrong, but I was not even aware of the possibility of a motion for summary disposition until I saw that notice over the weekend. So I'm at something of a loss because again, I simply do not have a dispositive motion.
All right, very well. So you're asking the court to grant you some time to get your hands on the motion and review it and be ready for the hearing. Is that what you want to do?
Yes, Your Honor. I would obviously I need to have the motion and certainly an opportunity to respond to it. And I apologize that I simply didn't realize it until I saw the notice to appear over the weekend. That was the first time I had any inclination that there is a motion for summary disposition out there.
Mr. Cunningham, anything, sir? It's kind of it's kind of one of those situations. Unless you're an incredibly starchy and mean judge, lawyers who practice in front of you that are competent and are there to do their job, and they say they need a little more time to do something, it's kind of hard to not set it over. So my inclination.
Sure, Judge. I don't have any objection. Mistakes are made. I did. So this is the second time that this motion has been up for hearing, and I did send a copy of it to Mr. Lowe back on September 16th, but I can send another copy today.
Yeah, if you could, Mr. Cunningham, if you could send it to me, I'd appreciate it. My email address is simply mfergustrom, spelled as it is on the screen, @lawdollar.com.
Okay, if you could give it to me again, MFERGERSTROM.
GESTROM.
GES Fergustrom at the same as Mr. Lowe's lawdollar.com.
Correct.
Okay.
Thank you very much.
Oh, all right. Actually, so you were on my last one as well, actually.
All right. So 2 weeks, 3 weeks, what do you need on this?
Well, I would need an opportunity, to respond, obviously, and then of course we'd have a hearing after that, Your Honor. So I guess I'm at your discretion.
Yeah, you're on my roll. Okay, that's So we're gonna go ahead and set it for the, let me put you at the 18th, November 18th. And we'll set that at 9:45.
Thank you, Your Honor.
Your
thank
Honor,
you,
I have
Mr.
I have
Cunningham.
a settlement conference. Yeah, no worries. Your Honor, I have a settlement conference that morning on the 18th at 9 o'clock.
At 9 o'clock. You think you'll be able to drop in at 9:45, or if I set it at 10, is that better for you?
10 would be better for me, Your Honor.
I'll go ahead and set it at 10 o'clock a.m. on the 18th of November, 2021.
All right, thank you, Judge.
Thank you, Your Honor. Thank you, Mr. Cunningham.
Yeah, no worries.
Have a good day, gentlemen.
Thanks, Judge.
All right, this is case number 21-58327. This is Standard Rehabilitation Incorporated versus Suburban Mobility Authority Smart. The matter is before the court after looks like issuance of a bankruptcy stay. Your appearance for the plaintiff in this matter, please.
Daniel McGrath, Your Honor, on behalf of plaintiff.
And your P number, if you will, Mr. McGrath.
75237, Your Honor. Sorry about that.
Thank you, Councilman. No problem. For the defendant in this matter, your appearance at this time.
Good morning, Your Honor. Andrea Malinowski, P82842, appearing on behalf of defendant Smart.
All right, thank you, Ms. Malinowski, and good morning to you. So I have this listed as a settlement conference date. I also see this document that's sitting in front of me that had to do with an administrative closing. Oh no, that's something else. Not to worry. I
Okay, I was gonna say, when you said that.
Me too.
Not to worry. All right. All right, somebody update me. What's going on here? Have you made some progress, or what do you need from the court?
Your Honor, I was under the impression that today was the date and time set for defendant's motion for summary disposition. But if that is not the case, then I guess we're gonna find a new date for that.
That was my impression as well.
Well, let's let me see. Because somehow that one kind of slipped by me. So looking for. And I don't have a motion for summary disposition contained in the court's file. And let's see what I've got on my register of action. And I don't have an updated register of action, and I don't have the motion for summary disposition contained in the court's file. I take it that both of you have read and are ready. Mr. McGrath, did you get a response into that?
Yeah, I did. I mailed it to defendant and I faxed it to the 36th District Court. Obviously, if it's not in the file, I would put one in the mail today as well if we adjourn this to kind of cover my basis. Or I can email it to the court clerk if that is an option as well.
Well, let me backtrack a little bit, because what I'm looking at, items contained in the file ending in 8327, but I also see an 8325.
They're consolidated.
I'm sorry?
They're consolidated, Your Honor.
So, Ms. Malinowski, that would be where your motion is in that, in the bigger file. All right, for some reason I thought that was not related to this. Okay, we're gonna make sure that this doesn't happen again. I do see now that I do see the motion for summary disposition. I also thinking that there is a response in here somewhere as well. That's how that was missed. Okay, so if you want to go into what your, what is the motion about? Tell me what your motion's about.
Your Honor, this is our motion seeking dismissal based on both Robert Yarborough and Ruben Yarborough having applicable insurance policies and higher priority than defendant Smart. Pursuant to MCL 500.3114, if there's an insurance policy for the injured person as either a named insured or a resident relative, that insurer would be the highest priority over the bus company operating under a government-sponsored transportation program. Robert Yarborough is confirmed to have been residing with his sister at the time of the accident, and she had a valid insurance policy with MetLife on the date of the accident. And his son, Ruben Yarborough, was residing with his mother, Robbie Yarborough, at the time of the accident, and she had a valid policy with Falls Lake. So that insurance policy for Ruben would be higher in priority than defendant Smart. So that's the basis of our motion is, you know, there's two other insurers for both of these individuals that are higher in priority than Smart, the bus company.
Gotcha. That obviously, Mr. McGrath, the rules regarding priority are as simple as they are complicated, and Ms. Malinowski has set forth the argument that there are other resident policies that are found in place, and that accordingly, those policies are should be the ones that are defending in this case, and Smart gets to be secondary or tertiary. What's so complicated about that?
Well, my argument, Your Honor, and again, obviously, it's in the brief. So it's I don't, obviously, if the court doesn't have that, I can just wing it, but it's on the Borges case line that, they are in the chain. And just because you're in the chain doesn't mean you get out. There's a decent, I would obviously be more resting on the authority in my brief if the court was had that in front of them. But it was going to basically be along the lines of, like, you're in the chain of priority. There might be someone else who's also in the chain, and that moves from time to time when new information is learned. But that doesn't necessarily avail someone of not paying benefits, and it's more of a pay and chase situation to ensure that the individual gets no fault benefits as they're entitled to in general. But again, it's, I would be more comfortable with, instructing the court that I was relying on my brief and had the court have reviewed the document.
All right. I thought that I had your brief here. I'm looking diligently. And after diligent inquiry, it doesn't appear that I have your brief. Hey, listen, and I hear your argument though, and that is that I do have your brief. I have it here.
Okay. First time my brief.
To the extent that Smart is somewhere in the chain that they should not be allowed to escape because circumstances can change along the way. I don't know how much weight that holds, though, when you deal with the significant legislative establishment of prioritization of insurance liability. And in this case, it seems that the research that is available at this point is unrebutted. And if it can be rebutted, then I need you to tell me that the individuals that are seeking relief, the Yalboroughs, if you will, that there is someone within the households where they were residing that have a policy in place, and the rules of priority would in effect create a requirement that those policies be dealt with because they're policies of priority.
Yes, sir. I again, Your Honor, I understand the court's, comments and questioning, and I would just, again, I'm just going to rest on my brief, Your Honor. But I do understand where the court is strongly from and your position on the matter.
Ms. Malinowski?
Your Honor, I would just state that Borges case that plaintiff cites too, it kind of is distinguishable from this case just because the issue in that case was whether the insurer could deny benefits only on the basis that there was some other unknown insurer out there that may be higher in priority. That's not really the case here. We've established that there are two identified insurers of higher priority for these two individuals. So I do think that case is distinguishable on that basis. And I think the priority rules are clear, and there are two other higher priority insurers for these individuals.
Yeah, I think that the case that is referenced and the argument that is made on that case supports the grounded notion that the goal of the no-fault mechanism is to make sure that an injured person has access to coverage, i.e. the assigned claims facility if necessary, but to make sure that there is a reality of coverage. And so if there is someone of higher priority or some entity of higher priority, and that higher priority cannot be discovered or is liquidated or whatever the case may be, then certainly under those circumstances, it would be appropriate to hold the secondary person in the case until you could get discovery to the bottom line as it relates to the entity of higher priority. That does not seem to be the issue here. I mean, the issue here seems to be straightforward, that there are policies in place that are of higher priority than Suburban, or I should say than Smart. Having considered the factual dynamics that are before the court and finding that there is no genuine issue of material fact as it relates to the claim brought before the court, that as a matter of law now, having reviewed the statute as it relates to priority, that there are policies of higher priority that were in place at the time of the accident that will step into the purported shoes of Smart, that indeed that is what the law would require under these circumstances. And for that reason, the motion for summary disposition will be granted where there are insurers of higher priority. So ordered at this time.
Thank you, Judge.
All right, and Madam Counsel, you have the email address where you can send the order in. Ms. Malinowski.
What was that? I'm sorry, Your Honor.
You have the email address to send your order to?
No, could you give that to me?
Yeah. That's Latifah, latifah.hunter@36thdistrictcourt.org.
Okay. All right. Thank you.
Thank you, Counsel.
Thank you, Your Honor.
Good day.
Have a good day.
A moment. All right, thank you for your patience. I had no clue that would take as long as it did, but this stuff gets a little complicated every now and then. So you get your firsthand upfront view of that reality. All right, let me go to Cam Marine. And the location there is 9666 East Jefferson, is that correct?
Yes, it is.
All right. And if I could, I'd just refer to it as the cold place, but I won't do that. So your name again for the record, ma'am, as I prepare to allow you to offer testimony. Your name again.
Carolyn Moulton.
All right, thank you, Ms. Moulton. All right, Ms. Moulton, it was brought to my attention by the plaintiff in this case that he had contact with another person, of Ms. Ernest or Tesser is the name that he uses. Is that someone that works for your agency or that has worked for the agency there?
Yes, so Tessa Ernst was the manager. She is no longer employed here. She stepped down.
All right. And but your agency keeps some records of boats that they service. Is that correct, ma'am?
Yes, sir. I was here during all of this.
All right. So you were, and are you familiar with this particular case?
Yes, I am.
All right. So you've heard the testimony of Mr. Simpson and the issues that he's raised regarding his boat upon the boat being surrendered to him. And just before I ask you that question, I'll come to Mr. Simpson. Just one other question. Mr. Simpson, at the time that you submitted your boat for safekeeping at CAM, was your boat in good repair and operational capability?
Yes, it was, definitely. Mhm.
All right, thank you, sir. So are you familiar with, you told me you're familiar with the business. What was the condition of Mr. Simpson's boat when he brought it in? If you would tell me, then you can go ahead and testify and tell me what you want.
Yeah, it was good, in good working condition. He brought it in for winter storage, asked for the engines to be winterized. So that's what we did. We winterized just the engines. We did put notes on the invoice that was sent to him regarding the water assist, which the water heater, the hoses for those were cracked and dried. So we were, we did advise that they should be, fixed. That was never, nothing was done after that.
All right, when was he advised regarding the water hoses being cracked and dry? Was that when he came in or at some later point?
That was in December of 2019. That was invoiced to him.
All right, and you said it was invoiced to him. The invoice was for the winterization, but did you charge any fee for water in the hoses or for the cracked and dry water in hoses?
It was only invoiced for the winterization of the 2 engines.
Okay. All right, so your agency never winterized the water in the hoses or the internal operations of the boat, is that correct?
That is correct. It was only asked that we winterize the engines.
And the winterization occurred in 2019, is that correct?
That is correct, yes.
So what would have happened in the subsequent year, because the boat was there for 2020 as well, with that?
So nothing would, right, he asked for summer storage for 2020, so nothing would have been changed. It just sits on the blocks and stands for the summer and the next winter.
So you indicate that you have an invoice regarding the fees for winterization and storage, and that you noted on that invoice dry and cracked and dry hoses, correct?
That is correct.
Or do you have a copy of that with you?
Yes.
And do you have that electronically or just?
Yes, I have it electronically.
Now, are you able to share that, screen share that with me?
Unfortunately, I can't screen share because I'm actually not on a work computer. We don't have microphones or cameras on our work computers.
All right. So do you have a physical copy of the document?
Yes. Yes.
Are you able to hold that up to the camera that
Print
you?
that? Yes. Give me 1 second. I'll print it out and I will hold it up.
All right. And Mr. Simpson, do you have a copy of the document that she's talking about?
I don't know. No.
I'm waiting to see it. I have a lot of documents, but I'm just looking through them right now to see if I have one that. the one
It
that
is
she's
invoice
mentioning.
number 818 from December 20th of 2019.
Okay, I have that. I do have that one.
Just one moment. So, you said, you referred to it as invoice number 818. You have a
Correct.
number on your invoices? Okay, all right, I'm looking now. I know you sent something in the file, and I have a couple of the invoices that are like 686 and so on and so forth.
Judge, I believe you might have sales order number 83 that has the same notes as well.
Right, I don't have, well, I have 818. I have, 686.
Oh, 818 you have the invoice?
Yes,
Okay, that's what we're referring to.
818.
Yes.
Okay. All right, and, Mr. Simpson, you have that one as well, correct, sir?
Yes, sir.
It says, hoses on hot water assist appear cracked and dry. All was, overfull on both engines, so on and so forth. All right, so that's what you're referring to when you say that you sent something to him indicating something about the hoses and, appearing cracked and dry, correct?
Correct.
All right.
If I may, Your Honor, if I may,
I'll come back to you, Mr. Simpson. All right, go ahead, Ms. Moultrie. We're going to treat that as this exhibit, letter A, defendant's letter A, will be the invoice 818. Plaintiff's exhibit number 1. Plaintiff's exhibit number 1 is a work order from Land Service. Work order from Land Service. And that's the item that refers to a total of $2,809.82. Right. All right, and you may continue at this time. You may continue at this time. Let me just for the record, let me say that item plaintiff's 1 is dated 7/12/21, and let me point out that the 818 item is dated December 20, 2019. All right, you may continue at this time, Ms. Moultrie.
Okay, so I'm sorry, can we back up? Can you explain what it is that the 2800 is for?
That's a claim. That's the estimate claim that has been raised by Mr. Simpson. An estimate where he had the vehicle estimated as to what the cost of repairs would be. And that's why that's the plaintiff's exhibit document that he made reference to as to what it would cost to get repairs done.
And what repairs would that be for? Because we did replace the water pump.
Well, we'll get back to that. I admitted that into evidence, and we'll talk about those things. But tell me what you, and I do have testimony regarding the repair of the water pump and regarding him having paid for repair of the water pump. But he indicated that he received this item as an estimate of things that needed to be done. That's what he's presented in his case. You may continue to what happened here.
Okay, so we winterized the boat, we invoiced it, it stayed on land until spring of 21. When we commissioned it to get it ready for so it was seaworthy to go in the water in the spring. And they took the boat out, they called us back, asked us to look over it again, that the water pump water was running straight out of the water pump. So they brought it back to us. And that's when we replaced the water pump, found that it was broken. And we replaced it and sent them an invoice and it was paid.
All right, so why is it that the water pump that was seemingly working fine when you presented the vote for storage, why would that be a problem at some point? Why did that come to a state of disrepair, if you know?
I don't know.
Would that have something to do with winterization? Would it have something to do with storage? To the best of your knowledge, if you will.
I wouldn't
Sir,
think.
if I may, like,
You do it that way. I'll come to you in a moment, sir. Can't do it that way. To the best of your knowledge, Ms. Walter, do you know if it had anything to do with whether winterization or with storage or anything?
It would not do with winterization because we did not winterize the water pump.
Gotcha. Okay. Go ahead. You can tell me. So, and you would not winterize the water pump because that had something to do with the water operations on the boat and not with the engine, correct?
No, we did not winterize the water because we were asked to only winterize the twin engines.
Okay. Gotcha. And the twin engines have nothing to do with the water pump, correct?
Correct.
All right. Anything else you want to tell me? Go ahead, ma'am. Take a moment, think about it, and I'll come to this gentleman next. But anything that you can think about that you want to tell me, go ahead. I'm listening to you.
Yeah, no, I don't have anything more to add. I mean, we winterized it. We made the notes. Everything was written on his invoice.
Now, when you're asked to make the, and I know I'm using the wrong word for it, but when you're asked to make the boat seaworthy, what requirements of due diligence are there in that regard? Go ahead.
There's a launch form that needs to be filled out before we launch any boat, whether it's inside or outside, so that we know exactly what the customer is asking for us to do.
All right, and so so there was some launch form in relationship to this particular launching of this watercraft, correct, ma'am?
Yes,
And do you have a copy of that?
I do.
All right, now.
It's
Go ahead, I'm listening to you.
Yep, spring launch 2021. And it was signed by Mr. Simpson on April 5th, 21.
Just one moment, I'm gonna see if I have that.
I know there's a lot of paperwork.
That's okay, trust me, I know a little something about it. I'm just going through some of the items, of course, Mr. Simpson, that you sent in, and we'll come back to you in a moment. I would indicate for the record, storage, the winter storage contract, 2019 through 2020. That is plaintiff's exhibit number 2. That document was signed, like the execution date on that was the 1st of April, 2019. Just one moment. And then I see a document entitled Sea Safe. Well, that looks like something, I'll ask Mr. Simpson about that. It looks like something at another location. Just one moment, I'm looking for it.
Mhm.
The record should reflect plaintiff's number 3 is storage reservation document. And that was signed on August the 12th of 2019.
Judge, can Ms. Moultrie spell her name, her first and last name?
I
Yes.
hear you.
I need the spelling of Ms. Moultrie's first and last name.
Madam Clerk, what are you talking about? Oh, you need this case? Madam Reporter?
No, just the spelling of the witness's name.
Oh, yeah, Ms. Moultrie. Yes, all right. Go right ahead again, ma'am.
Okay, first name Carolyn, Carolyn. Last name is Moulton, Moulton.
Okay, thank you so much.
You're welcome.
Okay, I don't see, I know there's an agreement for the court to look at that item, and so that's why I was looking for it. The launch item. Let me look at one more thing here. All right, so tell me about the seaworthiness issue when you presented that, when you were asked to make the item seaworthy. What was found at that time? What did you do in order to effectuate that result?
Okay, so on May 4th of 2021, we wrote a work order. Customer return boat request. We look over the work that was completed. State support side shaft is still leaking. Batteries for port engine not charging. When hooking up water pump, the water was running straight out of the pump. Technician wrote the water pump broken, needs to be replaced, which we did. Yes, replaced fresh water pump, test good, no leaks.
All right, and if you hold that up, let me see that, because I know that you can't screen share it. What's your, you have a receipt number on that document, do you?
Yes, sales order number 716.
Let me look for that, just one. Sir, you have that document, is that correct, Mr. Simpson?
Yes, I have. I'm looking for it now. I don't think I have that one. How much is it for?
716.
Yep, that's the sales order. So the invoice 13993. Look at that. Nope, down, right there. Okay, that would be invoice 13393.
Okay, 13393, right?
Yes, for the amount of $517.12.
I have that. I have two of those. Yes, I do have that.
Okay.
All right, that's the receipt that was generated as a result of the making the boat ready for the water. Is that correct?
That was for the replacing of the water pump.
All right, and the replacing of the stop, Mr. Simpson. I just want to know if you have the document, Mr. Simpson. The replacing of the water pump. That issue came about at the time that the boat was being made worthy for the waters, correct?
That was after the boat had been made worthy. It had come back.
Okay, they brought it back because of the water pump issue, correct?
Yes, sir.
Thank you. All right, so it's CAM's position in this matter that they had no contract or duty or obligation to winterize the internal water operations of the boat because their contract was to winterize the engines. Is that correct?
No.
Yes, sir.
Anything else you want to tell me, Ms. Moultrie?
Nope, that's all.
Sir, you've indicated your name in this matter as well, and Mr. Ian Hilgendorf, correct, sir?
Correct. Yes, correct.
And my court reporter now is probably going to need you to spell that last name, Mr. Hilgendorf. Do that for us again.
Exactly.
First name, Ian, I-A-N. Last name, Hilgendorf. Hilgendorf.
Okay, thank you.
Thank you.
Thank you. Mr. Hilgendorf, you've been sworn, as have been Mr. Simpson and Ms. Moultrie in this matter. And you work for Cam Marine as a manager there, is that correct, sir?
Correct. I just stepped in a few weeks ago for the previous manager, and I'm just getting, involved in this case today. So
were you working for the agency at the time that the boat was brought in 2019?
no. Although there was mention of shrink wrap at the time, and I did perform that back in 2019.
So you actually performed that particular service as it relates to the boat, is that correct?
Correct.
And so you were not involved in the winterization of the boat other than the shrink wrap, or you had involvement otherwise?
Correct. No, I
Just the
was
shrink-
not.
All right.
Just the shrink wrap.
And in shrink wrapping the boat, would it be anything on your part to pay attention to the internal water operations of the boat at that time?
Absolutely not. The mechanics put like a winterizing tag on for the work performed, and that was done. And all I needed to know was like that the boat was winterized at that level, and it's ready for me to, perform my job, shrink wrapping. So.
All right, and is it safe to say then that when you shrink wrap the boat, that you had seen the tag indicating winterized?
Correct.
Anything else you want to bring to my attention, sir?
Just going over all these documents for the first time this morning, what I've noticed is like the invoice for $300 of that winterization for the 2 motors. All right. There's no other indication that any other winterization process was done on that invoice. And I'm looking at like our prices that would indicate, winterizing like one engine is about $150 per engine, right? And then to winterize the water system, that's a minimum of $140. And then there's extra systems, and each one has a price. So at the end of the day, the complete winterization of the whole boat would probably be somewhere around $900 to $1,000. And that's what I'm seeing coming into this.
What are you saying, that would be charged for 1 year?
That would be a complete boat winterization for 1 year. Yes. On that size boat. So.
And that would be if the item is winterized as it relates to the motors and to the pumps and water supply lines, correct?
Correct, yes.
All right, sir. All right, anything else you want to tell me at this time, sir?
Nope, like I said, I'm kind of new to this situation and just looking this over, part of my job here as manager to understand what's happening, and that's what I'm seeing coming into this morning.
All right, sir. Thank you, sir. All right, Mr. Simpson, you've heard the testimony of the defendant agents in this matter, and what do you have to say in this regard, sir?
Just a couple of things. Basically, when I paid on April the 15th of 2021, the invoice for $813, they put on there, I asked them to once again, commission the vessel. They did the engines, the generator, the fresh water pump. I paid for this fresh water pump, checked the impellers, commission head, and then on May the 10th, when I brought it back, they charged me again for $517 for the water pump. And it's on there listed as well. We replaced the water pump. So obviously there's some discrepancy there on the dates. If I paid you one time on the 15th to put the boat in the water, commission it, and you put on here, we checked the water pump. Someone missed something. I leave and come back in May, and you charge me again to fix it. Okay. Number two, I have the winter contract storage from Camarina Contract Storage, the terms and conditions. Thing I have noticed about marinas is that they want all the business. They don't want to just do part of it. If you go take your boat, and I've seen this a lot of them, they're going to say, hey, we want to winterize your boat. We're not going to say, well, we're going to take the water system off and you can do that yourself. No, they want to shrink wrap it. They want to get all your business because this is how they maintain their money. On the winter storage contract for 2020 and 21, number one thing says winterized spring service must be contracted through the yard manager. That's the first line. Now, if you go down to 17, it says, it is understood that competitive or outside labor will not be allowed on any boat in the yard or any outside dockage or covered well unless the owner and the competitive outside labor execute and hold a harmless agreement in the form of substance acceptable to the company in the sole discretion. I've seen that happen too. If you decide, if they find, okay.
Let me stop. Where were you reading from? You were still in the storage contract?
Yeah, I'm in their storage contract for 2021. They have a winter storage contract.
Oh yeah, I know which one you do, but where you just read from, you said 17. That's not what I see at number 17. What number were you reading?
Okay, on the second page, I have number one goes down through 1 through 25. Do you see that?
Yes.
Okay, 17 says the yard does all the work below the rub rail. Does that start with?
All right, you didn't start there. That's.
Oh, okay. Yeah, I'm sorry. Yeah, I just highlighted the yellow. Okay,
Gotcha.
That's the paragraph.
All right, and that is actually referred to, Madam Court Reporter, as plaintiff's exhibit number 1, the winter storage contract. All right, sir.
Okay, and go ahead.
No, go ahead. Anything else you want to tell me? Go ahead.
Okay, no, and I was just mentioning that every Marine I've talked to, and I have done some research because I want to follow up, make sure that I was doing my due diligence once again. They want your business. They always, when they say winterize a boat, they don't try to separate it. They want to put it in a package. And winterization has a couple different ways. Once again, you do the engines and water system. If it has a water system, every Marine has told me that. I talked to West Marine, Kings Marina, a lot of local marinas in the area, and also did some research online. They don't separate those. And so I have always gotten my boat professionally done. Once again, when I say winterization, I expect you to be the professional and to winterize my vessel. Now I can pick my shrink wrap if I want, but you know how to winterize a vessel. You don't take it apart and say, we're just gonna do a piece of it. I have never seen that. None of the other marinas I've talked to said that. As a matter of fact, I was visiting Kings Marina and I spoke with the head of the dock there, and he mentioned to me that, well, hey, I've had boats left out in the lot and we'll complete them anyway if they haven't been done. We're not gonna leave them sitting out there, and we'll get with the owner later to make sure that every system is winterized. He said, but that's just a courtesy and a professionalism that we do. So if we know the boat for some reason hasn't had the water system, which he's had, he said, I will definitely, and you can call and verify this, but he said, I would definitely, we go out and do it and then get with the owner later. We just don't want to see any damage to their vessels. I wasn't treated this way at all. They knew if they knew the water system hadn't been done, they would have probably, I'm sure they would have had me sign something saying, you're going to do it yourself or you don't want to, or because you're not allowing us to do it. But they never had me sign anything like that to cover their bases. But they haven't. But it does say in there, and if I were to get someone else to do it, they would have definitely had to go through the yard master and get an agreement, as it states under 17, to get that done, because they want a part of the proceeds. Then normally that's what they charge, a part of the proceeds. If you get an outside contractor to come in on your property, they want that money. They want that revenue. So I wasn't treated that way. my boat was left unattended for 2 years, and I got a lot of damage. So I've really suffered behind this.
All right, so sir, you received the, sales order 83 that was issued on August 14, 2019, correct?
What I'm trying to look. I have to look through my papers again. But what is the sales order 83? What's on there? Can you tell me?
Yeah, I believe you submitted this with your package. Under that document, it provides to do winterized twin engines sales tax. It says 2 engines, and it says then generator not winterized, hot water tank assist, 3 mufflers drain.
Is that 93 or 80? That's like 83.
83.
I'm sure I received it. I was just looking for it. And it was in. Can you tell me the amount? I'm kind of looking at these amounts. It's easy for me to look at.
This document does not have an amount on it.
I sent that in to you?
Yes.
Okay.
Judge, I believe you received that from Cameron. Mr. Simpson would have the invoice for the winterization. The invoice, I don't have the number right for me, but it would be the amount of 303.
All right. So maybe I received it from their agency, but it has a second page to that doc that talks about 2 engines being weatherized, the muffler being drained, hot water assist.
I don't have that one.
All right.
All I did was I paid whatever they asked me to pay in order to keep the boat worthy, basically. I don't have that one. What they asked me to pay, I paid. That was
Gotcha, sir.
Mm-hmm.
All right, thank you. And the total amount that you paid to CAM over that period of time that they had your vehicle, give me your totals again, if you will, sir.
All right. I'm looking at about $5,500, $55,1205, and I didn't include another $500 for the paid for the other part. But I'm looking. When I totaled mine the first time, I came with $5,512.05.
Yeah, how did you come to that?
Okay. Well, I came to that because the winter store. Summer storage. In August of 19, I paid $1,460.90. I paid for shrink wrap $700 on 12/2 of 19. 12/20 of 19, I paid $1,003 for winterization. Got a $15.12 finance charge on 20th on 1/7 of 20. 7/21 of 20, I had winter storage again of $1,430. I commissioned the boat on August 15th of 2021 in the amount of $813.93. Last but not least, I didn't add this, on May the 10th of 2021, paid for those repairs again at $517.12. So basically it's over $6,000.
All right.
Charges.
Very well. All right. Give me, I need that, you went kind of fast on the first number that you paid. You said it was 1,400 and some number. The first amount that you paid.
The first amount you're speaking of?
Yes.
Okay, winter storage, 8/12 of 2019 was $1,460.90.
That's what I'm talking about. And then the wrap, you also went faster. You said it was 700 and what was it?
Well, $700 even. That was on December 12th. I'm sorry, December 2nd of 2019.
All right, and then the second winterization, or the winterization was $1,300 even?
No, it was $1,003. The total, yeah, I guess that was the total winterized. I paid 12/20 of 2019, $1,003.
Gotcha. And then you indicated another payment another payment of $1,430.
Yeah, that was for a winter storage of 20 of the next year.
Got it. And then the two charges as it relates to the repair or the making the item seaworthy and repair of a generator or something, correct, sir?
Correct.
All right, gotcha.
Mhm.
Do you have anything, Mr. Simpson?
Pardon?
Do you have any document, Mr. Simpson, that shows with any specificity that the item, that the boat was to be winterized as it relates to the internals, as it relates to the waterline systems?
Yeah, what I have, and as I mentioned before, I did research just to find out what winterization, boat winterization entailed. And
Yeah,
all I can pull up.
Let me stop you for a moment. I allowed you to talk about that. That's really hearsay. Really what really drives this case is whether or not you have an agreement that says with specificity that they would fix something other than the two engines. I know the argument that you're making, and I can take into consideration what other agencies like. The argument that you're making is that you understood the winterization service to include winterizing everything that had to be winterized in order to keep the boat from incurring damage. That's your understanding, correct, sir?
That's my understanding.
And you don't have any contractual document that you sign that says that with any specificity to you, correct?
No, I don't. All I have is their word saying that they winterize my vessel.
All right. And let me ask you, Ms. Moultrie, is there anything in your contractual agreement that excludes the repair, or sorry, that the winterizing of items other than the engines?
No.
And of course, on both sides, you know that that's the core of your problem here. It exists on both sides, and I'll give my judgment in just a moment. That's fundamentally what the underlying issue is that the court, and what this court has been searching for is a document that sets forth with specificity exactly what winterization means in this particular case. And that's why you have this case in front of me, because there probably needs to be something that specifies that winterization means this and it doesn't mean that. And I've heard the statements of Mr. Killendorf, and if I got it wrong, I don't mean to get it wrong, wherein he says, well, we can tell that it probably was not including other stuff because of the fact that the charges were not of the nature that they would be if it included other stuff. And so I've got you. Okay. Anything else anybody want to tell me before I make a decision in this case?
We do have it in writing now that each year we have a form specifically customers have to sign out and check off each items that they want winterized, because some only want us to winterize engines and they do the rest of it. At that time, we did not have that, that form being used, but it is something we do now because some people do want us to do only parts of the boat to be winterized and they do the rest.
And I do have one other thing too. That's the form. I do know you have that form, and because I did sign that form, I don't have a copy. I stopped in one day, Carolyn, and I was on my lunch break, and I came in, and you asked me to sign off. And I know you have a copy, and I know I'll never get it, but there's a copy that I signed saying what you were going to do.
I do have the launch form. I do have your launch form, but not the winterized form.
I know, and that's the one I'm speaking of. I'm not speaking of the launch form. I'm speaking of the winterization form. I wish I had gotten a copy, but I didn't. I just trusted that you guys would do what you said you would do. I know you have a copy, and you probably won't produce it. I wouldn't produce it in this case.
Oh no! If I had it, I would absolutely produce it. But I do not have it.
Right. I appreciate that.
Let me Let me just put something out there that is kind of intuitive to me based upon listening to people. You know, I've tried cases for 35, 36, 37 years now. I've been a judge for 29 of those years. Yeah, it's pretty, it becomes pretty easy for me to decipher when people are just about the business of trying to obfuscate or hide or lie or just trick somebody. This is not this case. That's not this case. If there was a form that was signed, that form would come up, and unless that form was somehow not included in the file in the way that it should have been. This case represents some critical kind of mistakes, and not just mistakes on one part, but mistakes on both sides of this, and I'll address that in my ruling. So I thank you for your participation in this hearing. I thank you for your testimony that's been offered regarding this matter. As I listened to the testimony regarding this matter, what becomes clear to me is that this was a contractual agreement for storage and winterization of a boat, of a sea craft, and that the vehicle, the craft was stored for a couple of years. The fees were paid for the storage of that vehicle, and that's not really the issue that's in dispute here. There was a proper storage. Indeed, there was a proper wrapping of the vehicle. That's not even an issue that's in dispute in this case. There was some arguments raised as to whether or not the wrapping should have been done without certain other things having been done first. The testimony of Mr. Killendorf has indicated to me that he has the signal that when there is a tag on the vehicle, on the vessel, I should say, that gives him the signal that he needs to wrap the vehicle or the vessel. The issue in this case is the nature of the contractual relationship that the parties entered into. And that contractual relationship is a relationship that is incomplete. And what would have completed or could have completed the nature of the contractual relationship is perhaps a form document that Mr. Simpson has indicated that he signed at the time that he contracted to have the vessel winterized, and that form specified the type of winterization that he was paying for. Well, two things come to mind here. One, it's so easy for parties to go back and forth and say, they got that form and they're lying to me that they don't have it. The other person says, I signed it in there. And then one party say, you're lying, you didn't sign such a document because we didn't have to. Listen, if Mr. Simpson signed such a document, he's an intelligent man, he presents himself well. The best argument here is that, why do you get a copy of that document? That's the best argument, okay? You sign something that's telling what you want and what you want to pay for, get a copy of it. So if you have to come to court, you present a copy of that document. The other side of it is that the business has the document, and what reasons do they have really to not perform the services according with that document, because that's what they charge for. They charge you for that. You sign saying that that's what you wanted. When they see that that's what you want, they're going to charge you for that. And they charge you for it, they get paid for it. So why would they have you sign something saying that we're going to do this, 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 and this, and then charge you for that, and then go take your wonderful boat and do half the service, wrap it up, and let it endure damage. So there's a failure somewhere along this line, and that failure really has to do with the contracted relationship not having the level of specificity that either side would want here. And so winterization appears to be a term of art. I allow Mr. Simpson to talk about winterization a bit from research, but I can't allow evidence in of what that term actually means unless I have a quote unquote expert on winterization of boats. And that expert could tell me in the industry, how the industry acts. I can't go by what may have been done by some phone calls or by a Google search or anything like that. You would have to pay an expert to come in, an independent expert to come in and say, Judge, this is what weatherization always means. It always means this. And I don't have such a testimony here. So in essence, what begins to occur here is that both parties essentially have to bear some of the risk that was associated with entering into a contractual agreement that did not have the level of specificity that the contractual agreement should have had. Cam, and it seems with them pointing out that certain pipes had some dryness and so on and et cetera to them, that from the outset of giving that kind of indicator, that they were taking the position that that's not a part of our duty to deal with that part of the vote. On the other hand, Mr. Simpson did not think that communication was of any significance, because in his mind, winterization was that anything that has to do with water lines, what have you, were going to be plugged up, winterized. And antifreeze or whatever it is. I don't have a whole lot of information about what all of that means, but this vote seems to have some degree of size to it, and with having some degree of size to it, it has bathrooms or a bathroom, water supply lines, and so on and so forth. And Mr. Simpson, from the very outset, clearly his assumption was that in winterizing, it would be not only the engines, but it would also be the other water lines. It seems all equally clear from the beginning that Cam's position is that, yeah, we want to do a good job with this guy's boat. We're rapid, we'll do all of that. But our notion is that what he wants those engines to be winterized, and then he wants us to wrap the boat, and that there is not an agreement to winterize the other part of the boat. Well, if Cam was going to exclude that, then they needed to exclude that with some degree of specificity. On the other hand, if Mr. Simpson wanted that, he needed to have that contracted with some degree of specificity. To a certain extent, in these kinds of situations, the court would then go to the expert. Well, who's the expert? Well, Cam does winterization, but Mr. Simpson tells me that he knows something about winterization. He tells me that he's been a boater for 17, 18 years, and he knows about winterization. He knows about what happens with this and so on and so forth. Well, Cam, under its present operation and previous operations, have been doing this forever and a day. They say that winterization can be bifurcated. Mr. Simpson says that winterization is never bifurcated. And where is the expert to tell me which one of those worlds are the real world here? There's really not anybody that can really tell me what that is. I think that what that means is that the parties equally bear a portion of the weight of that responsibility. And because of that, what I'm going to do is I'm going to sever that. I'm going to bifurcate that, and essentially Cam in this regard will have some responsibility of remunerating Mr. Simpson based upon the reality that it wasn't real clear what they were doing. It wasn't real clear to him. It wasn't real clear to them. And no written document really specified exactly what winterization was. And Mr. Simpson did not unreasonably rely upon the notion that the pipes would be winterized. He did not. If it's an unreasonable reliance, for example, if Mr. Simpson is saying that I expected them to take care of that. This, that, or the other in the boat that would have cost $3,000, $4,000, or $5,000 to do it, and they only charged $1,000, and he was expecting them to do $3,000 worth of work. That would be unreasonable. He should have got that in writing. If it was going to take $3,000 more to do that, he said, "Well, they signed for $1,000. I thought that was good enough. They were going to take care of everything." Here, the argument seems to be that it would have taken another $200 or $300 to do the other winterization. Well, I mean, you kind of leave it open there that it's not clear. There should have been a contract clearing that out. And that's why the court drove down to that question about, do you have something? I asked Mr. Simpson, do you have something with specificity? Then I asked Cam, do you have something to the contrary with specificity? Because that is the rub in this case. So both parties were operating from different positions, and the way that you resolve that is you resolve that contractually. You resolve that by some written document that defines exactly what winterization is. I looked at the storage contract. I like that storage contract. I mean, That's a mean, wonderful sucker there. That storage contract tells you in 25 points exactly what storage is. It tells you exactly, step by step, piece by piece, and part by part. It tells you exactly what storage is. A winterization contract has to have some language like that really kind of specifies that so that you rule out these kind of situations. So I was refreshed to hear that there is now a document that says that is a checkoff, because this kind of case can happen over and over again, especially when you have a year like COVID, because ideally people plan to put their boat up for a period and you come back and get it because you don't have this COVID shutdown stuff, and then you discover things that you can do all of your lives. But with this, you run into a situation where 2 years later, it's like, oh, we should have added that part, or I was expecting that part. And that's what happened in this case. That's clearly what happened in this case. And so both sides are going to have to bear some risk of loss in this matter. My determination is that in this case, that the plaintiff is entitled to recover $2,000 of the amount that was paid, and that the rest remains with Cam Marine. They performed the services that they should have performed, the repair of the engine, and then there may have been a double, but whatever that is, both parties failed to close the gap on what winterization meant. And because they failed to close the gap on that, a part of that burden lies upon Cam. If I was to weigh the burden on both, I'd say that's about a $4,000 problem. That's what they come out to, about a $4,000 problem. And so I cut that problem in half. And that's how that problem comes to a $2,000 problem. So my judgment will be for the plaintiff in the amount of $2,000, and I will award the allowable court costs and filing fees in this matter. And judgment will be in favor of the plaintiff in that amount. That's my determination. I wish both sides well, and I hope that you continue doing business and voting and all of that. Something that I've not done, and a bunch of friends that tell me that you haven't lived until you get a vote. But you guys make me think that maybe I don't want to get a vote. So.
Right, Campen. Thank you, Your Honor. Thank you.
Absolutely. I'll sign an order. You'll get it. One of my colleagues for many years, he's deceased now, Judge Willie Lipscomb, had a boat, and that's where he passed away on his boat. He had a heart attack, and he was winterizing his boat, and he had some other underlying health problems, and he had a heart attack in the middle of doing that. And then our chief judge now, Judge McConicle, Will McConicle, he has a boat out there.
Yeah, your name sounds familiar. I may know one of your boater that passed away. He sounds familiar.
Yeah, Judge Willie Lipscomb was a big, tall guy, like 6'7", 6'8", 6'9", or so, and 60-something years old. He had retired and was out there working on his boat. That's why he talked about boating.
Yeah.
Boating was and they tell me it's a little bit like golf, They say you can't do golf.
They say the first day you get into it, you love it, and when you sell your boat, that's the best day. The first day you buy one, it's the greatest day, and the day you sell it, it's the greatest day. No in between.
All right. Well, I wish you all the best to both sides, and you'll get a copy of my judgment in the mail very soon. All right. Good day to you.
Thank you.
Thank you.
Thank you, sir.
Bye now.
Deborah? You good?
I made it here. Hey, how you doing?
All right.
It was a very active Monday this morning.